Hello, I'm Rob Coston with Nautilus International. Some good news from Westminster to talk about today. On October the 10th, the UK government laid down in Parliament its new Employment Rights Bill, which seeks to update protection for workers. And what's particularly important for Nautilus members and of course all other seafarers operating from the UK is that it specifically looks at loopholes that have been exploited in the past by employers in maritime. I'm talking, of course, about the likes of P&O Ferries and what they did to our members back in 2022. So since then, Nautilus has been lobbying very hard in Westminster for some of the provisions in this bill. So I'm talking with our Director of Organising, Martyn Gray, today about the bill and what it includes. Martyn, thanks for joining me.
Hey, you're very welcome, Rob.
Thank you. So what kind of thing have we got in this bill, and what things has Nautilus specifically been putting in there and working towards?
I mean, the bill is a lengthy piece of legislation that's going to be coming through. And, you know, in summary, we're looking at rights for 0 hours workers, so workers that don't have fixed contracted hours. It proposes new rights for workers on those contracts, and it includes the right to be offered guaranteed hours and the right to reasonable notice of shifts as well. That's got potential maritime impacts where we see voyage contracts, where we see other elements of a casual workforce, which we sometimes see in seasonal contracts for operators such as CalMac. And some of the larger ferry operators operating on international routes as well, where they will have a pool of 0 hour workforce that they may now need to offer guaranteed hours for if they are regularly utilising them. And those guaranteed hours will need to be appropriate based on the historic usage of those workers. It also covers things like pay and conditions in specific sectors. So the bill includes provisions where we've got negotiating bodies that are going to be set up at school support staff and adult social care sectors in particular. Those bodies are going to be effectively responsible for considering and making recommendations on pay and conditions in these sectors. And those negotiating bodies will consist of employer and employee representative organisations. So you're looking at trade bodies and you're looking at trade unions. So workforce representation and employer representation working together with a little bit of government intervention in a tripartite way to try and develop a better framework of moving and elevating terms and conditions of employment in those specific sectors. We're looking at trade union rights being modernised and updated and rights with industrial action. So it makes changes to the law relating to trade unions, including the introduction of a right to a statement of trade union rights to workers being included in contracts of employment being made clear by an employer, as well as provisions for accessing workplaces for trade union officials and representatives, meaning that unions can go out to workplaces and actually access workplaces instead of sometimes being restricted to the outside of workplaces, and speak to workers that they are trying to represent and improve conditions for and be able to make that pitch against. So the likes of Amazon and the likes of Uber Eats and the likes of other companies that have had some more traditionally anti-trade union stances find that the playing field is a little bit more level when there is an automatic right for trade union officials to gain access to workplaces and workforces to describe benefits of union rights, as opposed to just the employers being able to effectively batter their workforce with anti-union rhetoric, which is what's been happening at some of these recognition battles that we've seen at the Amazon warehouses in Coventry in particular. And it also talks with enforcement of labour market legislation. So we end up with a new framework for the enforcement of labour market. And it gives the Secretary of State for Business and Trade responsibility for enforcing employment laws, which it already has, but it also sets up a better mechanism for making sure that labour market legislation can be enforced more effectively than what it is at present, because under sort of labour market enforcement mechanisms in the UK at the moment, there are a very limited number of resource positions available that allows for labour market enforcement, and that's typically done through HMRC and through the Treasury Department, and that's such a small number that they are only able to act on intelligence-led, so tip-offs effectively, where we then see action being delivered against bad actors instead of proactive interventions to stop employers from becoming bad actors where they might be falling short of this legislation. And it provides, in that with the enforcement of labour market legislation, it provides better for the creation of an advisory board to the Secretary of State on matters of enforcement. And on that advisory board, we would expect that to be representative of the world of work. So we would see likely the TUC taking a big part of that, as well as the CBI and the Confederation of Small Businesses as well getting involved. So we're looking at a variety of actors wanting to represent everybody's interests working together on labour market legislation.
Great. And I know there's some really important extra things to talk about here, specifically related to what happened with P&O Ferries. So my understanding, of course, is that P&O Ferries was able to exploit a loophole to allow collective redundancy for their workforce because of how the company was set up, of where the vessel was flagged, so that they didn't have to notify the Secretary of State that they were going to dismiss the employees and go through the proper process that they would have had to go through and talk to the union. So yeah, how does this bill address issues like that?
So there's a number of maritime aspects that are explicitly mentioned in the bill. We've got the collective redundancy notification for ships' crews. So it modifies section 193A of the Trade Union and Labour Relations Consolidation Act 1992. And it clarifies its applicability with relation to redundancies of ships' crews. So the bill specify that that section applies if an employer proposes to dismiss as redundant 20 or more employees at one establishment, so per vessel, within a period of 90 days or less. And that modification in the bill ensures that the section applies to some or all members of the ship's crew, even if they do not work in the same establishment. So it also goes a little bit further and helps get rid of some of the challenges that came forward through Seahorse Maritime versus Nautilus International, where an employment tribunal ruled that for the purposes of an employment tribunal, each vessel was a specific establishment. So it goes a little bit further in supporting that actually the likes of P&O Ferries, for example, the entire vessel operation could be considered an establishment, certainly where you're looking at services where there's co-cooperation and where a workforce isn't necessarily limited to working on just the one ship. They can work on a variety of vessels that are formulating either part of the service or part of the area within which the services are being operated. So that goes and means that what they did in terms of not sending in a HR1 form of notification for redundancies to the UK government in good order or good time would be explicitly unlawful and would be opening up the company towards unlimited fines and towards challenges with respect to the suitability of the directors to be able to continue being directors. It would put a question their good standing. And it also, what the bill does is an extension of the redundancy consultation requirement. So it again amends the Trade Union Labour Relations Consolidation Act of 1992 through that establishment, and it means that the Secretary of State will need to be notified, and it means that you cannot get away with a Zoom call the same day after stopping the operations. So it would completely mean that any operator, any service provider, anyone who employs ships' crews that are in the UK and that would fall within reasonable terms of links to the UK with regards to this legislation would need to inform the Secretary of State to let them know what the plans are in good order and good time. And as part of that notification to the Secretary of State, there will be a requirement to engage with employer representative organisations where they are recognised. And with P&O Ferries, that would have been Nautilus International, and it would have been the National Union of Rail, Maritime and Transport Workers too. So it would have meant that the company would have had to enter into negotiations in terms of redundancies and changes to employment, and would have allowed for both organisations to make representations that way. And it obviously means that there is a sort of redress were that not to happen. I mean, outside of the explicit maritime mention of those bills, there's other areas which are going to be, sort of helpful to maritime workforce, even if it doesn't specifically mention them. So you've got the protection of workers in public sector outsourcing. So the new provisions that amend the Procurement Act of 2023 allow for transforming the workers and outsourcing contracts. So where there is government work that's currently government work, government employees participating in it, should that then later become outsourced, it does protect the functions related to any sort of operations, including maritime, and could protect the rights of seafarers or other maritime professionals if they are transferred to a new employer through the Procurement Act 2023 or public sector outsourcing. Also, again, guaranteed hours, reasonable notice of shifts, the right for payment of cancelled shifts, and strengthened enforcement of labour market legislation will all be really helpful in terms of not explicitly mentioning seafarers, but will have applicability for UK-based and domiciled maritime professionals and workers as they're operating in the UK with strong links.
Yeah, so one question our members might have, thinking back again to P&O and some of those other budget operators, is does a bill like this disincentivize companies from getting rid of their UK-based workforces and instead going to a low-cost crewing model, bringing in people from elsewhere that they can pay less and offer poorer conditions to? Will this bill prevent that kind of action?
It will, in itself, no. In itself, no, it wouldn't do that. It would mean it would take an employer longer to have to go through that process. They would have to inform the Secretary of State what they were planning. They would have to engage in a effective and proper redundancy process by either electing workplace representatives or having already a recognised trade union be able to intervene in that position and act as the workplace representative because they're being recognised for the purposes of collective bargaining. So it slows that element of it down. But let us not forget that also on the 10th of October, laid before Parliament, were the regulations to the Seafarers Wages Act, which was a piece of legislation that was passed in 2023 that's been waiting regulations since being passed in 2023, which have now finally been laid to Parliament through the negative procedure and take effect from the 1st of December 2024. This means that seafarers working on vessels that formulate a service that calls into the UK at least 120 times a year, which covers 98% of all RoPax operations and 92% of all ro-ro operations in the UK ferry sector, are covered by this act, which means that the UK national minimum wage equivalent has to be paid to these seafarers. That further acts as a disincentivization towards moving towards a low-cost crewing model, because when those ships are in UK waters, when those ships are operating, irrespective of the nationality of the crew, they will have to pay them at least the UK national minimum wage. And when you look at P&O Ferries, who are employing people post 2022 on hourly rates as low as £5 an hour, it doubles the crewing cost for that. When you factor in the need to pay for the flights of people to join and leave the vessels, when you add in the French legislation, which restricts them working in certainly cross-channel waters for more than 2 weeks, when you add in changes that we're seeing to, again, employment rights bill in terms of access to workplace for union recognition and representation, it all serves to add in to make what P&O Ferries did more and more unachievable and a less attractive option. And P&O Ferries got away with doing what it did in the way in which it did it by offering slightly more than what they would likely have to pay out at an employment tribunal to anyone that took them through that mechanism. And that is the way they did it. They costed the price of that into the calculations of doing that by being able to eradicate a significant amount of crew cost and replace that with theirs. So they have taken that upfront hit and are now looking at realizing the benefits of the savings of that on the back of being able to exploit crew wages. This, from the 1st of December, becomes a lot more of a significantly more challenging for them to be able to undertake, because their crew costs in a large number of roles from the 1st of December will double with that. And there is an automatic right to workplace access for trade unions and the right to being able to speak to these people, to be able to actually try and collectivize their abilities to do that, which means that the onus is back on trade unions to organise these workers and to push for more and push for better. It helps to level the playing field and the difference between the bad operators that are using exploitative crewing practices and aren't using non-local labour resources to operate vessels, it means that their models become a lot more expensive and unsustainable, and it helps to support those operators that are doing the right thing, that are committed to a local workforce, that are committed to training and development, that take a long-term view on the way in which they operate their business, and are more supported by having that sort of less challenge when it comes to pricing competition, because the likes of P&O Ferries and Irish Ferries are able to offer discounted tickets on the back of not paying their crews what they should be paid for the work that they're doing.
Yeah, thank you. That's all good news. It's good to hear that's being addressed elsewhere. So going back to this bill, of course, it's got a long way to go before it becomes law. There'll be chances to make amendments to it as it goes through the Commons and the Lords. Is there anything else that Nautilus is hoping for and will be lobbying for during that process? Any further changes?
Yeah, I think there's quite a bit of work to do with it, and this was never going to be all things to all people. So we're expecting that we will see pushback from business, as well as we'll see pushback from trade unions in terms of looking for what it is that's needed for more. From our perspective, we're looking for a mandatory seafarers welfare charter, the welfare charter, the voluntary charter that was launched last year, that's been operational, that's working. We're looking to make that more mandatory, and that will help solidify terms and conditions of employment, certainly in the UK ferry sector, as well as have some impact elsewhere as well. That will mean that it's the working conditions again are best practice, are more supportive of maintaining a local workforce, and not fatigue inducing, are supportive of being good quality terms and conditions of employment. So it will cover elements of pension entitlements, to which they currently are none, either in the face of the Seafarers Wages Act or the face of the Employment Rights Bill. There are no direct pension requirements for seafarers that are employed outwith of the UK jurisdiction. So this we would like to see added onto that protects seafarers as they move towards old age. There's again guarantees for sick pay, to have it not just based on the basic rate of pay, but overall remuneration, so that companies can't drive down basic rates of pay, so that in the event of accident or injury, they only have to pay a minimal amount of compensation and support out for those seafarers. So we're looking at, again, tightening loopholes, working through what's going to be best practice to support maritime professionals in the UK, and to support the employment of local maritime professionals in the UK as well. Part of the stuff that's in the bill that's going to be helpful for that is expanded rights for union recognition. So Schedule A1 of the Trade Union Labour Relations Act is going to be changed, and that's going to change the support for union recognition threshold when going through the statutory process from at least 10% of workers to a minimum of 2% of workers through the regulations. So that's going to be helpful in actually making it easier, where a union doesn't necessarily have great penetration in terms of membership density, but is being told by a workforce there that there is an appetite for change and recognition, that they can get in at a slightly less restrictive level to deliver that, which is going to be helpful for us in certain workplaces to be able to push for more, push for better, with having fewer core members in benefit at the time that we're pushing for that, but being able to support a wider cohort within maritime that we will be able to then represent and deliver meaningful change for through collective bargaining. I've already spoken about the right to access workplaces, which is going to be very, very helpful to request access, allowing for meetings with workers, recruiting, organising them, facilitating collective bargaining, and delivering more and more. And it allows for a process to be in place with access principles. What we'd like to see with that, though, is digital rights, so that we'd like to see access to workplaces on a digital as well as a physical basis. So that's company SharePoints, company intranets, having digital union notice boards where you can send out information to that's fairly open, that the company can read and review, but that allows for the workforce to have better access to that, and that it's still supported by the company. There's some other things that have no impact on Nautilus members as well that are included in there. But what could be quite helpful, again, is the removal of restrictions on facility time, which means that facility time for trade union representatives, the restrictions that are regarded that in the public sector certainly get removed. So it repeals sections 172A and 172B of the Trade Union Labour Relations Consolidation Act. It removes turnout and threshold for strike ballots, so it amends 226 of Torica. And it removes the requirement for minimum turnout for industrial action ballots, and it gets rid of the hurdle that we have in maritime of balloting people who are working at sea more than half of the time, which is the challenge where we have to send out postal ballots. It's also going to change the way we can ballot people by moving towards digital and electronic balloting, and we're pushing to make sure that's done in an appropriate way. So it means that members who are unhappy with the way collective bargaining has worked out and wish to be able to take further action, that's going to be easier, simpler, and quicker to do for maritime professionals, because digital balloting, threshold levels, the removal of the need to have to do everything by post, all of that means it's a lot more beneficial for seafarers in particular, but other maritime professionals, to participate and feel engaged in the democracy, so that we'll end up with probably better turnouts and quicker results, meaning that we can move forward with action a lot quicker and resolve some of these long-standing issues that we're seeing with certain employers a lot quicker than what we've been able to do previously.
Yeah, thank you. It's a huge amount of detail. It's a lot to understand, and I know we'll be getting to grips with it over the next months as this bill goes through. But I think the top line is that we've achieved a lot already, and I know you and our General Secretary and others at Nautilus will be pushing hard to secure any of those further goals and ambitions that we have for the bill. So, Martyn, thank you very much and best of luck with it.
Thank you.